Junaid is walking toward his ex-partner's house with a jerry can of petrol. He intends to start a fire while she and her children are inside. But halfway down the path, he is stopped by police. They find a cigarette lighter and a petrol-soaked cloth rag in his pocket. No match was struck and no property was damaged. Does this constitute attempted arson, or, given the danger to the family, attempted aggravated arson? To determine if this is a crime, the law provides a specific statutory process designed to resolve these ambiguities. This legal framework was established by Parliament to define exactly when preparation becomes a punishable attempt. That authority is found in Section 1(1) of the Criminal Attempts Act 1981. This framework governs inchoate offences, meaning crimes that are currently incomplete. The law justifies intervention because waiting for a defendant to successfully kill, steal, or burn property would prevent the police from acting until the harm is already done. This flowchart tracks how the 1981 Act processes a set of facts to determine liability. Every scenario must be passed through 3 mandatory filters: Actus Reus, Mens Rea, and the doctrine of impossibility. The first filter is the Actus Reus, the physical requirement of the offense. Section 1 specifies that an attempt requires a positive act. It cannot be committed by an omission. Consider parents who maliciously neglect and starve their child. If the child survives, the parents cannot be charged with attempted murder. While a completed murder can be committed through a failure to act, the statutory definition of an attempt explicitly demands a proactive step. If an act exists, it must meet a specific threshold. It must be more than merely preparatory to the commission of the offense. The law must distinguish between someone getting ready to commit a crime and someone actually executing it. In R.V. Gullifer, a man jumped onto a greyhound track to disrupt a race. He hoped the race would be declared void so he could reclaim his losing bet from the bookmaker. The Court of Appeal quashed his conviction for attempted theft. Lord Lane established that for an attempt to begin, the defendant must be on the job, having moved past preparation to embark on the crime proper. Gullifer failed this test. He still had to climb back over the fence and actually present his ticket to the bookmaker to demand the refund. Compare this to the case of R.V. Jones. The defendant shortened a shotgun, put on a disguise, and jumped into the back seat of his victim's car. The court held that by climbing into the car and pointing the weapon, Jones had crossed the line in the sand from preparation to execution. Because the threshold of more than merely preparatory is a question of fact for a jury, legal analysis requires examining these specific precedents to build an argument for both sides of the line. If the physical act is established, the prosecution must then prove the required mental state. This leads us to the right branch of the flowchart, the mens rea. The general rule is that the defendant must specifically intend to commit the full target offense. In R.V. Wybrow, a husband wired his wife's soap dish to the electricity supply to electrocute her. A completed murder charge only requires an intent to cause grievous bodily harm. But on appeal, the court ruled that attempted murder strictly requires an intent to kill. Relying on a lesser mens rea, like recklessness, will fail to establish liability for an attempt, even if that same recklessness would suffice for the completed offense. This high standard has one major exception involving crimes of ulterior intent. In aggravated criminal damage, the defendant must cause property damage while possessing an additional ulterior state of mind regarding the danger to human life. The ruling in Attorney General's Reference, No. 3 of 1992, clarified how this applies to attempts. The defendant must specifically intend the physical act, the property damage, but they can be merely reckless regarding the ulterior element of endangering life. This split standard allows the law to punish dangerous behavior during incomplete crimes without violating the principle that the primary act itself must be intentional. The final structural question is what happens when a crime is factually impossible to commit successfully. The 1981 Act contains a specific provision for these scenarios. Under Sections 1(2) and 1(3), factual impossibility is no defense. A pickpocket who reaches into an empty pocket, or a thief who tries to open a safe with a teaspoon, is still liable for an attempt. This was confirmed by the House of Lords in the case of R.V. Shivpuri. The defendant was caught carrying a package he believed contained heroin or cannabis. In reality, the substance was a harmless powder. The court held that because liability is assessed on the facts as the defendant believed them to be, the impossibility of the act did not erase the blameworthiness of the attempt. Returning to Junaid, he was arrested halfway down the path with a metal lighter and a petrol-soaked rag. Applying the Actus Reus Filter, walking toward the house with accelerants crosses the Jones line. He is on the job and more than merely preparatory. Applying the Mens Rea Filter, Junaid admits he intended to damage the house by fire, satisfying the base charge of attempted arson. Finally, the exception for ulterior intent applies. His awareness that the family might be home satisfies the recklessness requirement for the aggravated charge. Inchoate liability is established by systematically processing the facts through this statutory and jurisprudential framework.